the court's shockwave on suppressors, and the NFA. What just happened? Something extraordinary just shook the firearms world. The entire legal framework surrounding suppressors, commonly known as silencers, has been thrown into chaos. A federal appeals court has walked back its own decision. The Department of Justice has reversed its long-held stance, and the long-hated $200 tax stamp on suppressors is officially on the chopping block. This isn't just another legal fight. It's a turning point that could redefine Second Amendment protections in America. Before diving deeper, let's make this clear. What follows is educational discussion, not legal advice. Firearms law is complex, state-specific, and constantly evolving. Anyone considering action with suppressors or other NFA items should consult qualified legal professionals. How a small gun shop sparked a constitutional battle. The story begins in Louisiana with George Peterson, a 60-year-old gun shop owner who never expected to be part of a constitutional revolution. ATF agents discovered an unregistered suppressor in his shop, something he had fashioned from a solvent trap kit. The result? A 2-year federal prison sentence. Most people in his shoes would have accepted their punishment quietly. Peterson didn't. His attorneys launched a bold attack on the entire suppressor regulatory system, arguing that the National Firearms Act violates the Second Amendment. They leaned heavily on the Supreme Court's Bruin decision, which demands that the government justify any modern firearm restrictions by pointing to regulations that existed in America's founding era. That is a much higher standard than courts used in the past. Initially, Peterson's case looked doomed. A 3-judge panel of the Fifth Circuit Court of Appeals ruled that suppressors weren't arms protected under the Second Amendment, labeling them mere accessories. For gun rights advocates, this seemed disastrous, as it implied magazines, triggers, and other essential components could be stripped of constitutional protection. The DOJ's rare about-face. Then came the shocker. The court did something nearly unheard of. It withdrew its own published opinion at the request of the Department of Justice. Appellate courts virtually never retract already issued rulings, which is why legal scholars immediately recognize the gravity of this move. Between March and May of 2025, under the Trump administration, the DOJ reversed its official position. For decades, the government had claimed suppressors were dangerous and unusual items requiring strict regulation and special taxation. Suddenly, the DOJ admitted its past arguments were wrong. It acknowledged suppressors and similar components are indeed covered by the Second Amendment, and that restrictions on their possession infringe on the right to bear arms. While the DOJ still suggested that some modest regulations might survive, this admission shattered nearly 90 years of precedent. This reversal was nothing less than a tectonic shift. It's like the foundation of a building cracking. The entire regulatory structure built upon it now looks unstable. Independence Day reform. Trump delivers on his promise. While the legal world wrestled with this upheaval, the political arena was equally dramatic. On July 4, 2025, fittingly on Independence Day, President Trump signed H.R. 1, nicknamed the One Big Beautiful Bill. This legislation abolished the $200 NFA tax on suppressors, short-barreled rifles, short-barreled shotguns, and other heavily restricted items. The change will officially take effect on January 1, 2026. Getting this through Congress was anything but easy. The House barely passed the measure by a razor-thin margin, and the Senate required Vice President Vance to cast the deciding vote. Initially, lawmakers wanted to fully deregulate suppressors through the Hearing Protection Act, but procedural obstacles meant they had to settle for eliminating the tax alone. Still, the impact is enormous. That $200 fee, when created in 1934, equated to almost $5,000 in today's dollars. It wasn't meant to generate revenue or improve safety. It was designed to price ordinary citizens out of exercising a constitutional right. Wealthier Americans could afford the tax, but working-class gun owners could not. Removing it is the most significant reform to the NFA in nearly a century and sets the stage for wider challenges. Why the dangerous weapon narrative collapses. Anti-suppressor arguments have long leaned on safety claims, but the data tells a very different story. Of the nearly 5 million legally owned suppressors in the U.S., only about 44 are linked to crimes each year. That's a crime rate of about 0.003%. In fact, the ATF's own 2017 memo admitted suppressors are rarely used in shootings and pose minimal public safety risks. So what do they actually do? Suppressors reduce noise by 20 to 35 decibels. A gunshot with a suppressor is still around 130 to 140 decibels, similar to a jackhammer or ambulance siren. The silent weapon myth Hollywood loves to promote is pure fiction. Suppressors don't make firearms whisper quiet. They simply make shooting less damaging to human hearing. And here's the real kicker. Many countries treat suppressors as safety tools, not dangerous contraband. In places like Norway, you can buy one over the counter. Sweden, Finland, Portugal, France, and even the notoriously strict United Kingdom allow licensed citizens to own them. Meanwhile, the U.S. has spent decades treating them as if they were weapons of mass destruction. Ironically, even the U.S. military now issues suppressors with its standard rifles to protect soldiers' hearing and improve battlefield communication. What happens next? The elimination of the $200 tax has created a massive constitutional headache for the government. The original legal justification for the National Firearms Act rested on the tax clause of the Constitution. If the tax is gone, then what grounds remain for requiring registration? Without that fig leaf, regulators must now prove such restrictions are consistent with historical practices from the founding era, a task virtually impossible to meet under the Bruin standard. Peterson's case, still awaiting full court review, could become the landmark decision that forces nationwide recognition of suppressor rights. Should the Fifth Circuit rule in his favor, conflicting rulings in other circuits could make the Supreme Court step in, potentially reshaping firearms law for generations. Meanwhile, industry growth adds further momentum. The number of suppressors manufactured exploded from about 5,000 in 2000 to nearly 490,000 in 2023. The global suppressor market was valued at $320 million in 2023. 2024, and is projected to nearly double by 2033. With such rapid expansion, powerful economic interests now align with constitutional arguments for deregulation. Even the bureaucratic side is improving. ATF approvals that once took up to a year can now be processed electronically in just 4 days. When government systems become this efficient, it's harder to argue that delays and paperwork serve any legitimate safety purpose. They look like burdens for the sake of burdens. A constitutional turning point. The years 2025 and 2026 may go down as the most consequential era for Second Amendment rights since the 1930s. Suppressors are the tip of the spear, exposing weaknesses in the entire NFA framework. Once this pillar falls, other long-standing restrictions may soon collapse as well. The revolution isn't over. It will take time, setbacks, and continued litigation. But the direction is clear. Suppressors are increasingly being seen for what they truly are, hearing protection devices, not the sinister tools of movie villains. With taxes eliminated, constitutional recognition acknowledged, and the government itself admitting decades of error, we are witnessing the largest victory for suppressor rights in American history. The only question left is, will you be ready to take advantage of these changes when they finally arrive? Stay prepared, stay aware, stay free.